This lecture deals with the material in Chapter 3 of the textbook, which covers the functions and sources of law. Some of the materials covered in the chapter we've gone over before, but as you've probably seen in the textbook, kind of layers concepts on top of each other. So we will be constantly referring back to materials covered before. One other thing I wanted to point out, now that you've had some familiarity with the textbook, is you'll see that this textbook is structured in such a way that there's notes at the side of the text in the margins. And these notes are actually an excellent tool for outlining and understanding the topics that are presented in the chapter. So again, pay attention to those. So again, Chapter 3 deals with the sources of law and the function of law in our society. And again, when we think about it, we can think of the opposite of law as being anarchy. As pointed out in the slide, the definition of law is rules of conduct that have been promulgated and are enforced by the government. The opposite of a legal society is a society governed by anarchy. And, there are anarchists out there that believe that there shouldn't be any laws. They're somewhat a marginal group, but there are people out there that don't believe in any law whatsoever. Again, law is important to us because we use the law to define our society's rules of conduct. And in doing this, we have order and predictability. The issue of defining the society's rules of conduct illustrates the fact that laws can be different in different societies. Even within the United States, certain types of conduct that are permitted in one state are forbidden in other states. So again, it's whatever society has defined in its rules of conduct. Where do we find our law? In the American legal system, we can find laws and laws being made in all three sources of government, or all three branches of government. You recall those branches of government are the judiciary, the court system, the legislative, are elected bodies that enact laws, and then the executive. So all three of the branches of law are involved one way or another in creating laws. And thinking about it, the legislative branch is Congress at the federal level, the Assembly and the State Assembly and State Senate at the state level. They create statutes which define laws. The executive branch of law, president at the federal level, governors at the state level, promulgate regulations. We'll see that the regulatory system is part of the executive branch of government. And finally, the judicial branch issues court decisions, which can have the effect of law. So again, this illustrates how all three branches are involved in making law. The case presents a fact pattern at page 64. It's case number 4 of the pregnant waitress. And this fact pattern involves a waitress, Diane Dobbs, who was terminated by her employer, Western Ribeye Restaurant, because she became pregnant. And the fact pattern is to be considered in deciding what types of law, if any, might apply to her claims. Does she have constitutional claims? Does she have statutory claims? Might she have administrative or regulatory claims, or common law claims? So again, we need to look at all these sources of laws to find out whether or not there might be a claim. One source of law in our society is constitutional law. And again, we're talking about sources that are different than the groups or entities that promulgate. A constitutional law is law that arises out of the constitutions of either the United States, the federal constitution, or the individual state constitution. And again, so we look to these various constitutions to determine sources of law, and we consider this our first and foremost primary source of law. At this point, it's important to understand the difference between primary sources of law and secondary sources of law. Primary sources of law are actually the law itself. And again, these are laws that are promulgated by the various branches of government. Secondary sources of law, on the other hand, are not really laws themselves, but rather explanations of laws. So an example of a secondary source of law is the textbook we use in this class. Various practice guides, magazines, law reviews, things like that, or other examples of secondary sources of law. Again, secondary sources of law are writings that attempt to explain or interpret primary sources of law. And all of you have probably heard the phrase that the United States Constitution is the supreme law of the land. The U.S. Constitution, again, was established at the very beginning of a republic when the United States was formed, and it was enacted in order to establish the organization of the government, to set forth a division of powers between the federal and state government, and to protect individual rights. The protection of individual rights is protection from governmental overreaching. And these protections are embodied in our Bill of Rights, which are the first 10 amendments to the Constitution. Again, what's important and interesting to note is these, although the Bill of Rights are labeled as being amendments to the Constitution, they were actually in place and enacted at the same time that the Constitution. These Bill of Rights include such fundamental freedoms as freedom of speech and press, freedom of religion, the privilege against self-incrimination, the right to a lawyer, the right to a trial by jury, and protection against unreasonable searches and seizures. And another important concept that we have in our governmental system is the idea of separation of powers. And this is the division of power between the various branches of governments, the legislative, executive, and judicial branches. And we have this separation and the concept of checks and balances in that the power amongst the governmental branches is divided in such a way that each branch can kind of act as a check and a balance on the power of the other two, and thereby maintaining a balance of power amongst the various branches. The important thing to keep in mind in the separation of powers, however, is the doctrine of judicial review. This is the ultimate check on the power of government, and that is the power of the judicial branch of the government to determine what laws are valid, and in addition, to interpret those laws. The American system of government is a federal system of government. And by that term, we mean it's a system in which the authority to govern is split between a nationwide central government here in our country, the United States federal government, and regional government that controls specific geographical areas, again, in the US, the states. There are many, many other nations that have federal sources of government. You think of most United Kingdom, for instance, is a federal system of government. Certainly in Germany and Mexico and many, many other countries have federal systems of government. Under federalism, certain powers are reserved to the central federal government, and certain powers are reserved to the states. And again, there's a consistent tension between those powers. And this is a healthy dynamic tension, and certainly in evidence today. As I mentioned before, the doctrine of judicial review is very important and constitutes the ultimate check on the power of a government. This doctrine was established by the court system itself, the United States Supreme Court, in the very famous case of Marbury versus Madison. And again, that case established the concept of judicial review and the fact that the courts have the final say about the validity of a law. And again, as the text points out, is a very good question, is presumably legislatures, when they enacted statutes, believed that they're valid and that those statutes are constitutional. Otherwise, they wouldn't have enacted them. The doctrine of judicial review essentially says that no, the court has the power to essentially override the wishes of the legislature, and in fact decline or to hold statutes to be unconstitutional. Judicial review is very, very important. It's the basis for invalidating many laws, including laws that sanctioned racial segregation, laws against same-sex marriage, limits on campaign financing, et cetera. You can go on and on and on. It's the doctrine of judicial review that's overturned many of these laws. If the court holds that a law is unconstitutional, the legislature and the executive branch are powerless to reverse this. The only alternative that the legislature or the executive branch to do is to try to either enact new laws which achieve the same purpose but are constitutional, or appoint new justices to the Supreme Court that'll rule in favor. And so again, we see that going on now, very, very controversial Supreme Court, and how the Supreme Court has been altered throughout the years through appointments to the court. Okay, so we've talked about the first primary source of law being constitutional law. The second primary source of law is statutory law. And again, these are laws that are enacted by the legislative branch of the government. State legislatures, in California, the state assembly and state senate, or the United States Congress, which is divided between the House of Representatives and the United States Senate. The statutory laws are enacted and organized into codes. And codes are simply a compilation of statutes which organizes the laws into subject matter rather than the date of enactment of those laws. So in California, our California codes are divided and labeled by the subject matter. We have a water code, we have a code of civil procedure, we have an evidence code, we have a civil code, again, many, many codes. In the federal system, the codes are labeled by numbers rather than, and we call them titles, rather than named. However, the titles are related to a certain topic. So Title 11 of the United States Code, for instance, deals with the bankruptcy codes or bankruptcy statutes. Title 28 of the United States Code deals with the organization of the court system. Ordinances, on the other hand, are laws enacted by local governments. And again, these are part of statutory laws. So for instance, laws enacted by the City Council of Norwalk. These are ordinances. They are certainly part of statutory law. Going back to the Diane Dobbs case presented in the textbook, the textbook points out that her termination as a result of pregnancy is a potential violation of Title VII of the 1964 Civil Rights Law. And there's a quotation from that law at page 71 of the textbook, which says that it shall be unlawful employment practice for an employer to discriminate against any individual because of such individual's race, color, religion, sex, or national origin. So the question presented is, does termination as a result of pregnancy or because of pregnancy, is that sexual discrimination? And this, it's not clear. It requires an interpretation of the statute, which is done by the judicial branch of the government. As pointed out in the text, in 1976, in the case of the United States versus Gilbert, the United States Supreme Court said that pregnancy discrimination based on pregnancy is not sexual discrimination. As a result, in 2020, Congress amended Title VII to include pregnancy as part of the definition of sexual discrimination. So again, this illustrates the ability of the legislative branch to modify statutes in response to court decisions. The third primary source of law, in addition to constitutional and statutory law, is administrative law. And these are laws or regulations created by administrative agencies. Administrative agencies touch all aspects of our lives, pointed out in the slide, agencies such as the Internal Revenue Service, the Environmental Protection Agency, the Department of Motor Vehicles, on and on. These are administrative agencies that affect us. And again, administrative agencies fall under the category of the executive branch of government. So again, this is where we see the executive branch being involved in the lawmaking process. The text points out administrative laws can fill in the gaps presented by statutes. For instance, as the text points out, the question of whether winnings in a lottery constitute income and therefore taxable under the Internal Revenue Code. The Internal Revenue Service adopted regulations, which in fact provided that these lottery winnings do constitute income and they're therefore taxable. Extending it to our Diane Dobbs case, the text points out that Ms. Dobbs may have potential remedies under regulations that have been issued by the Equal Employment Opportunity Commission, the EEOC, and regulations under Title VII. So again, you can look at the regulation, one of the regulations that's been adopted that's set forth in page 74 of the textbook, and make your decision whether or not or termination as a result of pregnancy is a violation. Another thing to point out that administrative agencies not only make laws through regulations, but they also investigate violations of the law and have their own enforcement provisions. So the Internal Revenue Service has its own investigative arm, its own criminal investigation division, and also has its own essential court system, a tax court system, which operates parallel to the United States court system. Similarly, in California, we have the Workers' Compensation Appeals Board. Workers' Compensation Appeals Board is a regulatory agency, and it has its own enforcement division, its own court system to hear and adjudicate claims under the workers' compensation law. The third or the final source of law, primary source of law is common law. And the common law, again, is judge-made law, in part arising out of the courts interpreting constitutions and laws created by the legislature. So again, when we hear the phrase common law, you can also think judge-made law. This is laws created by the courts. Common law often arises not just because of interpretations, but also an application when there is no statute, regulation, or constitutional provision that applies. When the United States was first created, the English common law formed the basis of our legal system. Obviously, in the hundreds of years that have gone by, we've had statutory laws enacted. Many of these statutory laws have codified common law principles, which have become essentially part of our statutory law. Another thing to keep in mind is the concept of stare decisis. And stare decisis is a very, very important part of our common law system. And there are two aspects of stare decisis. One requires lower courts to follow the interpretations of laws by higher courts. So a California Superior Court, a trial court, has to apply California law as interpreted by the California Supreme Court or California Court of Appeal. In the federal system, federal United States District Court has to apply the law as interpreted by the Courts of Appeal, or the United States Supreme Court. The other aspect of stare decisis is the idea that is set forth in the slide that once a court has decided one way on a particular issue, it will normally decide the same way in future cases, unless the judges can be convinced of a need from a change. And again, the Supreme Court can overrule prior precedents. One of the most famous instances of that was the case of Brown versus Board of Education, which overruled an earlier case that had upheld racial segregation in public education. Brown versus Board of Education explicitly overruled that prior case and held that racial segregation is improper. On a more contemporary basis, we had the Dobbs versus Jackson Women's Health Organization case decided in 2002, which is a decision of the United States Supreme Court, which held that the Constitution of the United States does not confer a right to abortion. And in doing that, the court in Dobbs overruled cases of Roe versus Wade, a 1973 Supreme Court case, and Planned Parenthood versus Casey, a 1992 Supreme Court case, which had recognized the right to an abortion arising out of the Constitution. The Dobbs case involved the constitutionality of a 2018 Mississippi state law that banned most abortion operations after the first 15 weeks of pregnancy. So this Mississippi case was enacted by the Mississippi legislature, knowing that it was in violation of Roe versus Wade and Planned Parenthood versus Casey. And it was enacted, one of the purposes of enacting it was to challenge those decisions. So what happened in that case, that the Jackson Women's Health Organization was Mississippi's only abortion clinic, sued Thomas Dobbs, who was a state health officer with the Mississippi Department of Health. The lower courts prohibited the enforcement of the Mississippi law with injunctions. And these injunctions were based upon the rulings in Roe versus Wade and Planned Parenthood versus Casey, which had prevented states from banning abortion before fetal viability. In 2022, the Supreme Court issued a decision that by a vote of 6-3 that reversed the lower court rulings, and 5 of the 6 justices joined in the opinion that explicitly overturned Roe versus Wade and the Casey case, holding that abortion is not a constitutional right because the Constitution does not mention abortion. And the court further held that the substantive right to an abortion was not deeply rooted in the country's history. So again, for better or worse, the law, well-settled law, at least well-settled since 1973 law, was overturned. And we now have a system where the right to an abortion varies depending upon what state you live in. And again, this is an example of our federal system of government, showing that laws can be different in different states. The last the slide you're looking at now is a summary of the sources of law. This is figure 3.3 in the textbook that you can look at that analyzes the various sources of laws. It's a good summary of what's discussed in chapter 3 of the textbook. All right. The last thing I'll commend you to is the discussion about the hierarchy of laws. This is in figure 3.2 of our textbook at page 77. Again, this is a good discussion of the various levels of laws and their hierarchy. All right, this concludes my lecture regarding chapter 3 of the textbook.